Hello, everybody. My name is Tim Tang, and I'm Director of Enterprise Solutions at Hughes. My role is to look at the digital transformation of industries and try to anticipate where markets are headed to make sure that our managed services align with the needs of the future needs of the market. Today, I have the privilege of speaking with Todd McClelland. Todd is a partner at McDermott, Will, and Emery. Todd, could you help us understand why should somebody care about what a lawyer has to say about cybersecurity? You ordinarily don't put these two things together.
Nor do most people want to talk to lawyers anyways. No, we certainly have a lot of experience with breach. In addition to being able to advise clients on the law, this kind of nebulous concept, we actually have lawyers who have a lot of experience in this space. Have a lot of we've seen it all. So we can be very helpful to clients who are perhaps handling a breach for the first time and just need someone who's a trusted advisor to walk them through the process. In terms of the roles we play, there's a variety of things we do. First and foremost, we can help them conduct the investigation, work with their internal teams, work with the forensics provider. We also have the advantage of this thing called the attorney-client privilege, which means that communications with us or at our direction can be privileged, meaning that if they come to get sued or investigated, those communications do not have to be disclosed. Now, we can't protect facts. Bad facts are bad facts, but we can protect a lot of the internal communications that get shared during the course of the investigation. Now, there's a lot of other stuff we do as well. There's all 50 states, PCI, HIPAA. There's a variety of different notification obligations if a company has a breach. We deal with those regularly. A lot of them get very tricky in terms of how you interpret them. So, for example, in a ransomware attack, someone gets access to a system. Is that access to the data for purposes of triggering notification obligation? That's something we deal with routinely. Communications, we help clients with a lot with their internal and external communications. Figuring out how are they going to talk about this internally? When are they going to tell employees? How do they tell the world about this? What do they put in their press release, their securities filings? There's a lot in communications that goes on when it comes to dealing with the breach that we help them with. Law enforcement, we regularly engage with the FBI, the Secret Service, insurance recovery. We'll talk more about that, I'm sure, but that's something where how you manage your carriers, how you recover insurance if you have cyber liability or other insurance. That's something we do quite routinely. And then, of course, dealing with investigations by the government, PCI, litigation, government investigations, all that. That's what lawyers do.
Todd, how about we just jump into it? I'm an operator. I walk in the office one morning and I realize I've had a breach. What do I do? How do I respond?
So how you respond to a breach is going to depend upon the nature of the breach. Well, what's your first priority? Your first priority as an operator or whoever you are is to continue being able to do business. So if it's a ransomware attack, and so that we're all on the same page, a ransomware attack is where someone gets in, plants certain malware, and it encrypts data. It encrypts whether the data, your systems, you're not able to use it. And the only way you can decrypt it is if you pay the ransom, hence the name. And so it's an extortion scheme. So if it's ransomware, if it's a different type of attack, all those are going to vary how you're responding. But there are certain common things. We would advise, get counsel or someone who can advise you on how to go through and respond to a breach. Someone who has real experience dealing with a breach. If you've got a plan, you should follow your plan. You should know who your team is. Organize your incident response team, which we'll talk about more later. But you should have a team in place that, whether it's HR, risk management, various other, your CFO, whoever, this kind of core team who can help you with this. It's a crisis essentially, or they can be. And so you'd handle it accordingly. If you have insurance, you may have to immediately notify your carrier so that you can be able to recover from them as you go through the investigation. So you want to focus on containment, remediation, obviously, working with your IT teams. If you have external help through a vendor, that's definitely something you want to pull in. So there's a lot of first steps, but a lot of it's going to be dependent upon the nature of the incident that you're experiencing.
It seems like when be hit with a crisis of this kind of magnitude, it's very easy to make a lot of mistakes. Can you talk about some of the mistakes you've seen clients make?
So yes, lots of things that we see. The first thing to think about when you've got an incident is you've got a limited time before what we call breach fatigue, before it sets in. First of all, people want to return to normal as quickly as they can. In the early stages of a breach, the kind of excitement, oh, we're breached. Not always great if it's your company. But there's that kind of excitement. But after a very short period of time, people are ready to move on. So you've got a limited period of time to get operations back up and running, conduct your investigation, and deal with everything you've got to deal with. So that's the first thing. And what a lot of companies will do is draw it out, not respond in an appropriate and timely manner, and that creates issues. Your communications is something where a lot of people, that's where we see a lot of issues in terms of the nature of communications. Some companies will never go, disclose it, even though they should, and that can turn to regulatory, other kind of legal issues. Or maybe sometimes they're too quick to disclose. We had a breach, but it didn't affect X, Y, and Z. Then a week later, they'd find out through their investigation, yeah, it did affect X, Y, and Z. So how you manage your communications is something that people get wrong as well. Failing to notify your insurance, how you engage forensics if you don't pull them under the attorney-client privilege. Their deliverables and whatnot may not be protectable, and that can be problematic in litigation. So there's a lot of things that companies can very quickly get wrong.
Mm. Can you speak a little bit, and as you work with clients who have been breached, what kind of consequences have they incurred? What kinds of penalties, what kinds of business impact has the breach had on their tangible business impacts has the breach had on their business?
So you can think about the financial cost. I'll get to that in a second. The first thing I would say is that, yes, the financial cost can be very hurtful for a company and damaging. And some companies have gone out of business as a result of some breaches. But the one thing that's the hardest to recover from, maybe, is the damage to your reputation. If you're a company who gets associated with a breach, that really hurts your brand. It hurts your ability to do business, keep business. You will lose business. I mean, there's just a lot of impact, and that's hard to put a dollar value on. But in terms of out-of-pocket costs, there's a lot of things to think about. First, and the obvious one is going to be just the cost to do the investigation, hiring counsel, hiring forensics, and then the internal costs, because you have people who should be doing other stuff that's bringing in business, growing the business, and the like, and now they're being diverted to something which is not ultimately productive for the company. The cost of doing containment remediation has cost. A lot of remediation involves deploying new technologies, implementing new controls. That can be very costly for an organization. For example, we see a lot of companies when they've had a ransomware attack will go out and license some kind of endpoint protection tool or something like that. Has a cost. Not saying they should have already had it, but that's certainly a part of the remediation activities that they undertake. I mentioned before that all 50 states now have a breach notification law. To sit there and mail out all these letters cost money, and if you've got a couple $100,000 or a couple million, those are a couple bucks each. That adds up quickly. And if you throw on other costs like what is the mailing, the printing the letter, all that stuff, it quickly adds up. And if you add free credit monitoring, that's costly. And of course, if it's a PCI breach or somehow related to your cardholder data environment or credit card data, well, now it's a whole different tale, because number one, under certain brand requirements, MasterCard, for example, you have to hire a PCI forensic investigator, a PFI. That's costly. And then if you've got any kind of compliance deficiencies, cards that have to get reissued, fraud recovery, all that's you're gonna be the one who's paying for that. And of course, if you go public with the breach, there's almost always litigation. There are some very bored asbestos litigators who are looking for something new, and they're choosing the cybersecurity industry. And so if I was an asbestos litigator, I'd probably do the same. But they're going after companies who've had breaches, and it's always a race to the courthouse to see who can be the first to file. And of course, our regulators, the Federal Trade Commission and state attorneys general, they're investigating breaches. So you got a lot of people coming at you. There's a lot of costs you incur in terms of response cost, fines, penalties. There's a lot to think about.
We've talked about some of the consequences, and we've talked about a lot of the mistakes that people make when it comes to responding to a breach. Could you characterize what a good narrative looks like? What is a good outcome when someone gets breached? It's a horrible thing to happen, but what does a good storyline look like? What is a positive? What is the best case kind of scenario here in terms of how one can respond to a breach?
Well, if you've got a bad fact pattern, there's not much you can do to really make it good. If your systems have all been encrypted and there's been a whole lot of data loss, there's only so much we can do. Ideally, we will have handled the communications well. We will have timed them right. We will have said the right thing. Ideally, if it's going to go public, you're the one who writes the narrative, not someone else. If someone outs your breach, so to speak, and they're telling the narrative behind the breach, that doesn't put the company in a good position. We will have handled all the notifications right. If we have to notify the payment brands, we'll have done it in a way that reduces or at least mitigates the fines and recovery that you get charged for. And also, we want to think about the lessons learned. A part of a good breach response, we think, entails at the end undertaking a lessons learned activity where you think about what did we do wrong and that led to the incident. What are controls we can put in place? What are things we can do to prevent this from happening, or at least reduce the likelihood or severity of a future incident? So that's what we're thinking about. And so it's doing the right things, the right communications, notifications, and the like. But then also thinking about how can we put the company in the best position to prevent this from happening again.
One of the interesting things as we kind of delve into this is this idea of due care, this idea of saying there is a standard by which a business ought to be held responsible for in terms of having things in place to protect their business, in terms of being able to handle their customers' data. Can you give some guidance as to what does due care look like? Where does that bar, or where is that line drawn?
We're still trying to identify this impossible standard that appears to be out there, right? A number of states have laws that basically require a certain degree of reasonable security. The Federal Trade Commission imposes this unfairness idea that a company that has unreasonable security is therefore unfair and therefore in violation of the FTC Act. We haven't seen a precise definition ever, but you start to, when you look at the various enforcement actions by the FTC and state regulators, you start to see a pattern. If you're dealing with credit card data, the one standard that really would be most applicable would be PCI DSS. And of course, we're about to see the new version of that 4.0, probably in the second quarter of next year. So if it's anything related to the systems that process credit card data and payment card data, PCI DSS is the standard to go to. Outside of that, it gets a little bit fuzzy. Kamala Harris, when she was the Attorney General for the state of California, pointed to the SANS 20. We've seen other regulators point to NIST 853. Some folks look at ISO 27001. But the point of that is looking at standards. But there's other acts that represent or create a defensible position that you have reasonable security. For example, having a risk management program, doing annual risk assessments, doing tabletops, pen testing. There's a variety of different activities that no one thinks can be a silver bullet and put you in that category of we now have reasonable security, but collectively they kind of add up and give you that kind of defensible position.
Oh, that's helpful. I mean, one of the big challenges with cybersecurity is knowing how much is enough. It seems like you could spend enormous sums, and this is not a revenue generating part of the business. This is a cost center to a large extent. And so in an ideal scenario, you would only spend what you need to and not much more than that.
Yeah, absolutely. Yeah, it's, what is that kind of, fine balance between where we spend just enough but not enough, right? No company wants to be bleeding edge. Some companies will invest heavily in it because that's their business model. But for most of us, that's not our business model. It's just one of those costs of doing business. So we try to find that right balancing line where we have enough, but not too much, because if it's too much, then we're wasting money, right? Yeah. So what is the process we come by to figure out what the right balance is? First starting with credit card data. There's just no way around it. You've got to comply with the standard. Now, there's different ways you can do it. For some vendors, for some companies, maybe outsourcing my, processing of payment card data is my best way. Or maybe I'm hiring someone who's in managed services, or what other, kind of complementary technologies and solutions to let someone else take on that responsibility. And that may be one viable way to do it. At the end of the day, it's your responsibility. But if you can hand it off to experts who may be more efficient at it, you might be in a better net security position for perhaps even less money. But I think the underlying concept, though, is just doing a risk management and figuring out from a risk-based perspective, how do I most secure my data and operations to address the major risk?
When we think about risk, it seems like one of the important factors to think about is, what the threat actors are doing to understand how much defense do I need. In your engagements and support with your clients, what have you learned about the threat actors? How much do they know about their victims?
It's amazing. 5 or 10 years ago, or 5 years, I won't go that far back, but 5, 6, 7 years ago, whatever it was, when we first started seeing ransomware attacks, and these are just extortion schemes, the ransoms they were demanding were $20,000, $40,000. I mean, we had this one ransom where a client was based in the UK, and the threat actors said, pay us the ransom. It's like $20,000 or $40,000, and we'll give you a risk report and tell you how we got in, basically a pen test report, right? Yeah, it doesn't happen anymore. Nowadays, today's threat actors have gotten a lot more sophisticated. They know who they're going after. They're usually launched by phishing or spear phishing attacks where they're targeting individuals. They know who they're going after. They know what your role in the company is. They go on LinkedIn and other pages. They do their homework, and then when they target you, they get into your systems and they try to move laterally and kind of explore what's there. What do you have? How am I going to make this painful for you, where you're going to want to pay the ransom? And they've taken it a step further recently, which is not only are they doing this kind of smash and grab, get in and encrypt systems and demand a ransom, they're stealing data. And we're seeing some new threat actors where, like, if you don't pay them within, say, 72 hours after they've deployed the ransomware and encrypted your systems, they start slowly trickling out and releasing your data to the internet, but on the dark web, wherever. So the scheme is evolving. The threat actors are getting more sophisticated. They know what they're doing. We had another situation where a client, or where the threat actors had apparently, or said they got access to the client's cyber liability policy, and then started their negotiation point for their ransom at the amount of coverage they believe the client had. So they're smart. They know what they're doing. They're taking their time, and they're going to try to make it hurt, and they keep on evolving the model until you pay.
It's shocking kind of when you think about this scheme. And we've been talking quite a bit right now of the cybersecurity element, the protecting of the breach. But this year now, we've got a new aspect to consider too as well. Privacy, right? We have the California Consumer Protection Act that has kind of gone into force. And in that kind of scenario, when we start thinking about it, it's not just about the consumers that we're protecting. There's also an employee data element there too as well. Can you speak a little bit about that? Can you give us some kind of orientation of how to think about CCPA?
Okay, let's talk about the difference between privacy and cybersecurity for a moment. Security, what are we talking about? We're talking about how to protect access to data. We're talking about the that's the old CIA triad, right? We're protecting the confidentiality, the integrity, and the availability of data. Privacy is different. Privacy is more focusing on limiting your use of data that you collect about others, and making necessary disclosures to individuals about what you're doing with their data. So it's about disclosure, giving consumers rights to their data, and limiting your use and disclosure and sale and other things with people's data. So that's the way to think about the difference between the two. So with CCPA, which is like GDPR and many other laws that are out there, it gives California residents various rights as between them and companies. So a California consumer, for example, has the right to go to a company and say, give me a copy of my data, or get rid of my data, or maybe stop selling my data. There's various, there's certain very particular rights that are given to consumers. A company that does business, or that processes the data of a California resident, has further commitments to the consumer. In addition to honoring those rights, there are certain disclosure obligations to consumers. Here's what I'm collecting. Here's what I'm using it for. And if you are not accurate in those statements or don't abide by those requirements, the California AG has certain enforcement rights against the company. So, for operators and others in this industry, if you're collecting personal data, well, you have to abide by these requirements. You have to make certain disclosures. You may have to have a privacy policy. You may have to, if a consumer says, tell me what you've got about me, you've got to do that. Now, there's certain exemptions or certain size requirements for the companies. They exclude certain types of small businesses. But your bigger businesses are going to have to comply with CCPA. This November, with the election, there was a ballot initiative where a new law has come forward in California, the CPRA. So the old law is CCPA, which is currently in effect. The new law, which won't take effect for a couple of years still, is CPRA. It's really kind of an add-on to CCPA. It changes some things, adds some new requirements, and a couple pretty big ones for companies. If you're in California and deal with consumers, there's going to be new data minimization requirements. You basically kind of think of it as, once you conclude the purposes for which you collected the data, you're supposed to stop using it. You're only supposed to use it as for the purposes that you disclosed. So you collect X, Y, and Z about a person, and you say, oh, well, here's a new use I can make of my data. If you didn't disclose that previously, you can't do it. And when you're done with the data, you're supposed to get rid of it. So, a lot of companies are just inclined to keep data around and never get rid of it. That's going to be an issue under these new data privacy laws that are coming. Just two other things real quick about it. There's new audit requirements. There's a privacy audit requirement and a security. The privacy audit requirement is you're supposed to perform an analysis of the benefits you get from having data about these California consumers against the risk to the California consumer for you still maintaining and using their data. Similarly, the other requirement is a security audit requirement where you'd have to undertake some form of annual cybersecurity assessment. Now, we don't know much about these two requirements. It's just there's high-level requirements. As a part of this new law, there's a new California agency which is getting put in place, and they're supposed to come forward with some regulations in a year or two that'll give us more details. But the important takeaway is if you're a business you're in California and collect California data, you need to be thinking about this. You need to make sure you've got the mechanisms in place to deal with complying with these data rights, minimizing their use of their data, and doing these privacy and security assessments. And there's a lot more to it, but those are kind of some of the basics.
It's really surprising when you start thinking about the liability that's incurred by data. You made the point earlier that in retail, it seems like the de facto standard is collect as much data as you can, and then you'll figure out what you're going to do with it later on. And now it's data represents a meaningful liability, and you want to reduce that liability as much as possible. The challenge with California, though, is that they're not the only ones, right? All the other states are actually coming up with their own rules. So how's a retailer with a nationwide footprint supposed to navigate all these different playbooks?
That's the big $100 question, right? That's the question everyone's asking. Right now, it's just California. You got a few other states that have various requirements. All 50 states have breach notification requirements, but there is no other law currently like CCPA in other states. Now, if you're outside the United States, Canada's got a law, Mexico's got a law, Europe's got GDPR, and if you're outside the US, there's a bunch of other laws to be thinking about. But in the United States, it's California. When CCAPA was first introduced, we had about 12 or so states introduce this kind of copycat legislation, very, very similar laws. We had Mississippi, Illinois, Washington, Oregon, Texas had two laws, not to be outdone by anybody else. But all those bills went away for the most part. Washington, I think, is the next state that may have something. They've introduced about 3 different versions. There's one issue which is pretty contentious. It's whether consumers will have a private right of action under the law, meaning they can individually enforce it as opposed to having only the AG the Attorney General can enforce it. But I think we will see a law in Washington. We might see one in New York and maybe Illinois. I think the last few legislative sessions, bills have been introduced, they go away. But I think we will have more states. Now, the other issue is whether we'll have a federal law that will preempt, supersede, or complement CCPA. There's political dynamics in that. I don't know that we will. We probably definitely won't if we have if we want to have a Republican Senate. So that's something to continuously watch. A federal law would be helpful in theory if it preempts state laws, meaning that it supersedes and replaces them. If we don't, if it just complements them or sets a floor and allows states to come up with their own more laws, we're going to have a pretty challenging patchwork quilt of various requirements. If this Washington law has its own cybersecurity risk assessment, you're going to have to do maybe one for Washington, one for California. And what if multiple states have this? It's going to be a mess, which maybe that mess will prompt something on the federal level. I don't know.
What's really interesting is that this is really not an abstract concept, right? Because the idea and the probability of a data breach is so high that there's going to be real accountability here. That when a consumer goes to a retailer and says, I want you to forget me, and the retailer says, yeah, okay. But then they get data breached, and it turns out that consumer's information was part of what was released into the wild. That consumer is going to say, wait a minute, I formally told you to forget me, and you didn't forget me, and now I have to go through and cancel all my credit cards and redo all my accounts. And so there is meaningful accountability in terms of the operational and execution implications of these rules and of these regulations. What are you seeing with your clients in terms of how they are thinking about that? How are they operationalizing these new rules?
That's a great point, Tim, because I think what you've captured with your statement there is kind of the intersection where these two sets of requirements, the privacy and cyber, will interact and create kind of a mess, just to put it bluntly. Because you're absolutely right. Because the Attorney General have these, statutory enforcement mechanisms to bring actions against companies. They'll certainly investigate to see if you have in fact gotten rid of the data. But if you haven't, they'll have enforcement mechanisms to bring real financial, penalties against companies on the privacy side. But then you also have the security side, where if you didn't have reasonable security that led to the incident, now you're getting hit for both things, the privacy and the cyber. So the question then being, what do you do? Obviously the short answer would be, well, you comply. But it's more than that, right? On the privacy side, it's making sure that you have the internal mechanisms in place to be able to honor an individual's rights. So if an individual says, well, get rid of the data you've got about me, it's having that mechanism where you can ensure that, A, you know what data you have about an individual, and then B, knowing with confidence you can get rid of the data, if you have to. Now, the thing to know, this data deletion requirement is not absolute. There's various exceptions. For example, if you've got litigation against a person and the person who's suing you conveniently says, no, get rid of the data you've got about me while they're in the middle of a lawsuit, that might be problematic if you're trying to defend that claim. Or, you're not going to be able to go to your bank anytime soon and say, yeah, get rid of the data you've got about me, therefore forget about the loan I owe you. That's not going to happen. And there's exceptions for that kind of thing as well. But it's a matter of having a privacy compliance program, looking at your privacy policy, making sure it's up to date, making sure you have a compliance function that can handle these, the intake of these various requests and comply with them. That's the important thing to think at, is making sure, as I say, it's a program, not a project. If you go through a privacy compliance project and do it one time, you're not going to be forever in a state of compliance. You need a program in place to be able to manage this.
We've covered quite a bit of ground here, and I'm very thankful for your sharing your insights. We've talked about what happens in a breach, how that unfolds. We've talked about cybersecurity in terms of what the standards are, and we've talked about privacy too as well. I would imagine most retailers are not prepared for this, or at least that many are either not PCI compliant, or the new privacy rules might be something new to them. Can you offer some guidance as to baby steps? How do you get started? What's the maybe first step or two that one should take as they're thinking about doing this?
Yeah. So how do you get in through this? Where do you start? I think the first thought is think about your data. Understand what data you have. What are you collecting? Where is your data? Do you need to keep your data? What's the policies around your data? Really understand your data. If you're familiar with the data governance program, it's a good place to start. Then I would start thinking about, if I've got, let's pretend I'm going to have an incident. What are things I want to have in place at the beginning of that incident to be ready? If you process any kind of payment card data, have a PFI on retainer. MasterCard's got a 72-hour requirement that when you have an incident, you've got 72 hours to get a PFI engaged. It's not one of those. It used to be that whether you had to hire a PFI was the brands would tell you whether or not you had to hire one. Now under MasterCard's, I think it's like their February 2019 requirements, you automatically have to hire one. And 72 hours goes by quick when you're in the middle of an incident. I mean, it goes by faster than you can imagine. And it takes a lot of time to go out there, find one, contract with them, get them engaged. So get a PFI engaged, get external counsel engaged, or at least know who you would go to and develop a relationship with external counsel. Someone who's not, a lot of folks are quickly jumping on this bandwagon, but get someone who's been out there for a while and knows this, knows what they're doing. They've been through breaches and has had a lot of experience with them. Get a forensics provider ready to go. Now, you need to be thinking about attorney-client privilege here, and maybe it's your law firm who needs to engage your external forensics, but get a relationship one, get them engaged, and talk with your legal counsel on the appropriate means to do that. Get your incident response plan up to speed. Look at your plan. First of all, do you have one? If you don't, you need to get one. But once you've got one, make sure it's right. A lot of companies will overdo their plan. You just overthink it. Keep it simple, but think it through. Who is your, and think about, as a part of that plan, who is the team we're going to have that we trust in the company, who've got the various competencies and skills we need to effectively respond to an incident? Who from HR is going to be involved? 25% of incidents that we see these days are still done by insiders. So having someone from HR definitely makes sense. If you're investor relations, risk management, your CFO, or someone from the finance group. There's a variety of, legal, of course, I would say. IT, So there's a variety of people, but think through in advance, who is my team? You don't want to be assembling your team when you're in the middle of an incident. You want to think about a lot of the little stuff, your logging and controls. Is my logging sufficient? Note that under PCI, you've got to hold on the logs for a year. So are you doing that? Check your vendor contracts, know what your notification issues are or obligations are. Not only your legal obligations, but also your contractual ones. Now, technically, PCI is contractual one. You want to stay in front of understanding what your PCI notification obligations are. The brands change their requirements, and they change over time. So know where to look, and what your requirements are. Also, who you're going to notify. We've had incidents in the past where clients don't even know who their processor requirers are, much less who they're going to notify. And so we've spent way too many cycles just trying to help the client track down who they need to notify. That kind of stuff, it's easier to do in front of a breach than right in the middle of one. So, and last one I'd leave you with, though, is insurance. It is not a silver bullet. Don't exclusively rely upon it. But think about how much financial of a hit can you take. What would be the impact of an incident? What would happen if your operations were down for 5, 10 days, or whatever the period of time is going to be? Oh, one last thing. I'm sorry. Your backups with ransomware attacks. I could keep on going. I'm sorry, but with your backups, make sure you've got good system and data backups and test them. Have your team check. Let's pretend we have to recover from backups. Let's do it. Do we get to have do we have good backups? To what extent, what kind of data loss would we have? What's the recovery time? How long would it take for us to recover? Go through it periodically. So if you get hit with a ransomware attack, you can effectively, recover. Now, we're seeing ransomware attacks where they get in, they compromise the backups, or they're stealing data, which changes the game a bit. But if you can recover from backups, at least get your company back up and running, which is half the game.
Oh, that's tremendous. Thank you very much for sharing your expertise with us. And to our audience, we realize that we've covered quite a bit of ground. There's a lot to talk about, and we realize that one little seminar doesn't really touch everything or do justice. And so we invite you to kind of follow up with us afterwards. We provided our contact information, our email address, some websites that have some additional kind of materials for you to take a look at. And we encourage you to continue the conversation. This industry, the cybersecurity and privacy continue to evolve, and it's going to continue to change. And half the battle is understanding kind of what comes next. And we are understanding the complexity of the market situations, and really just wanting to help. Thank you very much for your time, and enjoy the rest of the show.